Meeting of the Budget Review Subcommittee on Economic Development, Public Protection, Tourism, and Energy. At this time, Madam Secretary, will you call the roll, please?
Representative All, Representative Bray, Representative Gentry, Representative Hart, Representative Lockett,
Here.
Representative Petrie, Representative Reed, Representative Weber, and Chairman Fugit.
Here. All right, today we have representatives from the Education and Labor Cabinet and the Public Protection Cabinet. They'll be presenting about the restricted fund transfer from the 2022 regular session, House Bill 1, and be given an overview of self-insured groups. At this time, I'll ask you to raise your right hand and be sworn. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God? All right, introduce yourself and begin your presentation, please.
Good morning, or should I say good afternoon. My name is Scott WILHOITE, and I am Commissioner for the Kentucky Department of Workers' Claims. It's a pleasure to be here.
Thank you, Mr. Chairman. I'm Sharon Clark. I'm the Commissioner of the Department of Insurance.
Thank you, Mr. Chairman. My name is Sam Flynn. I'm Chief of Staff and General Counsel for the Education and Labor Cabinet.
Thank you all for being here today, and go ahead with your presentation.
Okay, I think I'm kicking it off today, Chairman. As Commissioner of the Department of Insurance, I wear two hats. One is as Commissioner on my daily duties, and I report through the executive branch. My other hat I wear is rehabilitator, and that is a court-appointed. Franklin Circuit Court appoints me as rehabilitators when these funds are insolvent and going into rehabilitation. So today I'm speaking to you as a rehabilitator, wearing that hat. We've been asked to discuss the funds that were transferred last year into the two funds. So I'd like to give you a little background, please. The Associated Industries of Kentucky, AIK Comp, was formed in 1979 to provide workers' compensation coverage to its employer members. These were Kentucky employer groups. At one time, it numbered close to 4,000 members. When it was placed in voluntary rehabilitation on August the 5th, 2004, the members had declined to the number of 2,600. At the initial rehabilitation filing, the estimated shortfall was $58.5 million. It eventually grew to $100,344,560, and that included the special assessment for the Kentucky Special Fund. Under a court-appointed reorganization plan and the 2005 plan of assessment, AIK Comp assessed 3,862 employer members that had workers' compensation coverage during the period January 1st, 1999 through February 28th, 2005. Initially, 80% of the assessment was to be paid in cash and 20% in the form of a contingent promissory note. Under subsequent amendments to the plan, members were offered an option of a full and final release by paying the remaining 20%. In 2014, the court ordered the members to pay the 20% note. As of September 2020, $92,477,173 of the assessment had been paid, leaving a balance due of $7,868,488. There are no receivables remaining. Under the release provisions of the 3,862 members, 1,658 have been fully released, 662 have received a joint and several release, 451 have paid with no release, and 1,090 have been determined to be uncollectible or out of business. The remaining claims, those occurred post March 1st, and Commissioner WILHOITE will discuss why March 1st, 1997 is important. The claims that AIK that were paid for out of last year's funding transfer were prior to March 1st, 97. But the remaining claims post March 1st were transferred to the Kentucky Individual Self-Insurance Guarantee Fund. That's AIK. The other fund that was insolvent was the Kentucky Coal Producers. So a little background on them. Kentucky Coal Producers was formed as a workers' compensation group self-insurance fund under the laws of KRS 342, and it started operations on March 2nd, 1981. Its members numbered over 1,800 employers, and they were primarily small to mid-sized coal producers and some coal truckers. KCP provided coverage for Kentucky traumatic injury and Kentucky occupational disease claims until October 31st, 1991, at which time they stopped writing coverage. They then went into a runoff status. On January 9th, 1995, KCP filed for Chapter 11 bankruptcy in the United States Bankruptcy Court, Eastern District of Kentucky. Through an executive order by Governor Fletcher signed on August 3, 2004, and it was ratified by Senate Bill 86 in the 2005 regular session, responsibility for financial oversight of active, and I'll emphasize that word active, funds, that it was transferred from the Department of Workers' Claims to the Department of Insurance. Since KCP was in runoff and not active, and when I say active, I mean they were still writing coverage. Since they were in runoff, this fund was not transferred. KCP did not file any financial statements with the Department of Insurance, and we did not incorporate them into any of our regulatory review processes, which we did for the other funds that were transferred. In May 2011, Kentucky Coal Producers requested a meeting with the department and stated that the officers and trustees of the fund wanted to retire. At that time, they gave the department an update on its financial condition, stating that current assets would pay claims through 2025. The Department of Insurance, being the diligent people that we are, we conducted our own financial examination of KCP. What we found, and that exam started the next month, June 2011, completed in July 2012, that the fund was insolvent to the tune of $21,742,403, as opposed to their assertion that they were able to pay claims. In January 31st, 2018, Kentucky Coal Producers was placed under rehabilitation through the court. The then Commissioner of Insurance, Nancy Atkins, was appointed rehabilitator. Now, I will tell you, each time there is a change in commissioner, that person then dons that hat as rehabilitator. So when I became appointed, I took over the rehabilitation. Now let's talk about the lost portfolio transfer, which was the actual event that happened last year that required these funds. In the spring of 2021, my deputy rehabilitators confirmed to me that both AIK and KCP would not have sufficient funds to pay their financial obligations, to pay the claims of injured workers. As rehabilitator and with preliminary court approval, I initiated discussions with the Kentucky Employers Mutual Insurance Company and also with the Department of Workers' Claims to negotiate lost portfolio transfers of both AIK and the Kentucky Coal Producer funds. Now, a lost portfolio transfer means that the claim obligations that have been incurred will and would need to ultimately be paid are ceded to another entity. In other words, AIK and KCP claims would be given over to KEME to continue to administer. I approached KEME. They had a previous issue with the department where they did a lost portfolio transfer, and they did an excellent job. And I do want to express, once again, my appreciation for KEME's willingness to take those over. On June 6, 2022, Franklin Circuit Court gave final approval of the lost portfolio transfers. And in House Bill 1 of the 2022 regular session, page 64, language was included that provided for the transfer of $23 million from the Department of Insurance to the Department of Workers' Claims to, quote, account for bankrupt plans and shortfalls under the Workers' Compensation Funding Commission. Of this amount, $20 million is to support and pay the claims of the AIK and KCP, and $3 million was to cover the expected shortfall in the self-insurance fund. The funds were transferred from the Department of Insurance to the Department of Workers' Claims on July 1st, 2022, and then Commissioner WILHOITE will explain then what happened. I do want to make several points before I end this. Remember again, AIK worker compensation claims were in two buckets. Those prior to March 1st, when the legislation went into effect, and after, post March 1st. The claims that the AIK rehabilitation, which I was responsible for, were the ones prior to March 1st. The later claims are now in the bucket of the Kentucky Individual Self-Insurance Guarantee Fund. And Mr. Chairman, I can take questions now, or if you would prefer, Commissioner WILHOITE can speak, and we can address them at the end, whatever your preference.
We'll address the questions at the end.
Thank you, sir.
You can continue.
Very good. Thank you, Commissioner Clark. Again, my name is Scott WILHOITE, and I'm the Commissioner for Kentucky Department of Workers' Claims. Commissioner Clark did a good job summarizing the background of leading up to the events that led to the appropriation of the $23 million last year, essentially for those pre-March 1, 1997 claims from AIK Insurance and from the Kentucky Coal Producers Fund. And of that, I just want to go ahead and tell you, of those funds that we did work together with the Department of Insurance and with KEME, and basically those funds, again, I'm going to come back to this in a minute, this March 1, 1997 date, which is important. They were wrapped up in a package and done through a lost portfolio transfer to KEME. In essence, the state's obligation, the state's responsibility, the state about for future, everything's wrapped in a package. KEME now takes care of that, and KEME is in charge of that. That package was for approximately $20 million. Of that, $14 million, roughly $14,073,195 was to cover the KCP, and $5.7 million was for the AIK pre-March 1, 1997 claims. The remainder of that appropriation, approximately $3.2 million, went to shore up the 920 fund. Let me tell you real quick what the 920 fund, because we're going to be talking about that more here in a minute. The 920 fund's called the 920 fund because it's set forth in KRS 342.920. Not the most novel of name why we call it the 920 fund, but that's how we identify it as the 920 fund. The 920 fund was created in 2006, and it serves as a backstop, a safety net for the pre-March 1997 claims. So it gives up. Where if it's self-insured or sort of it comes up short, or there is money to pay for that. I also want to mention to you that 342.920 fund is funded through two sources primarily, through assessments. Basically for assessment of where we assign a penalty for a company not having workers' compensation insurance, and also through that process. But also through that process, we end up spending approximately $1 million a year for those claims that are otherwise for self-insured that were liquidated the pre-March 1, 1997. Out that. Like I say, we get $1 million, we spend about $1.2 million. So there's a continual shortfall of that. The rest of that money, that appropriation, went to shore up that fund to make sure that there is that safety net there to take care of. Because the number one goal, the absolute number one goal of workers' comp is to make sure that the injured worker is taken care of. That's the solemn promise that was made back in 1916, workers' compensation started, and it's the promise that continues today, that those claimants who were injured on the job and the benefits they're entitled, including medical care, that there is money to take care of that. And that's what helps take care of those pre-March 1, 1997 claims. So again, of that money that Commissioner Clark talked about for AIK insurance pre-March 1, 1997, and the KCP claims, which were all pre-March 1, 1997 because they stopped writing business, are all packaged up and in that package, a lost portfolio transfer to there. Now, when we talk about the future where we are now and so forth with that, we got to talk a few minutes about these group guarantee funds. The group guarantee funds, there are 3 group guarantee funds. There is the individual self-insurance fund, there is the co-employer self-insurance fund, and there's the group self-insurance fund. Of those 3 funds, we're primarily going to talk about the individual fund. That's one we're kind of here about. I'm sure some questions are going to be coming up about that. Of the co-employers and the group insurance fund, the Department of Workers' Claims has regulation, has oversight over those, more so oversight over that, including we can call security in that. That's not true with the not true with this group self-insurance fund. It's a different ball of wax. It was transferred over, and not only by executive order from 2004, codified in Senate Bill 86 in 2006. The question that one of the issues that we're having now is that the potential future liabilities and the potential future liabilities is involving the self-insurance group funds. We were advised, and the situation has come up, that they may, in fact, or they will be running out of money. They will either be running out of money this summer, or they will be running out of money come October. So the question of the day is, well, what's going to happen? Who is going to fund that? How's that going to happen with that group? I will tell you that as a brief background on this, again, that March 1, 1997 date. There's absolutely nothing within the Kentucky Workers' Compensation Act. There's nothing within KRS 342 that permits the Department of Workers' Claims. There's no law that permits the department to reach into a fund to help this situation. There's no law for it. There's no means for us to reach down. There is there is that 920 fund for the pre-March 1, 1997, but there is no such fund, no security net for the self-insurance group fund for the March 1, 1997 claims. And those claims primarily arise from AIK. We talked about AIK beforehand, and those AIK that were claims that were included with this the appropriation from last year, those again were for the March 1, 1997. There are still all those claims for post-March 1, 1997. And that's what the question of the day is, the funding for those, where they are going to run short on that. And again, I just emphasize that that's the fund where, unfortunately, unlike the other 2 self-insurance funds, the DWC does not regularly oversight those to the extent of the others. And also, too, we have no means of security. We have no law to go in, and neither Commissioner Clark nor myself, we are non-voting ex officio members over the self-insurance group fund. We can urge, we can suggest, we can do things, but we have no clear authority to say, do this, do that. The question now comes down to is that although we're not the creators of this problem, it is concerning because, again, the Department of Workers' Claims has never missed an opportunity, has never in its 108 years, 7 years of existence, failed to pay a workers' compensation claim, the injury, the treatment for it. I am concerned what's going to happen for these workers in a fund in which their money is running out. I guess that's where I come at this point, is to leave at that point, that we simply do not have the law to reach down, and it does cause me a good deal of concern of what to do with these funds or what to do with these claimants.
Any questions? Representative Gentry.
There we go. First of all, thanks for coming in. For me, from my position, that's a lot because I don't know a lot about this, but this sounds like a very grave concern to me. Mm-hmm. My biggest concern here is that we could possibly have injured workers out there that aren't getting claims paid. And whatever we do, we can't let that happen.
Absolutely.
Couple of questions. Again, if these questions are out of line, please tell me and please help me understand this a little bit better. So this group self-insurance fund that we have right now that is short, as I kind of understand this used to have several members to it.
Yes,
is that correct?
Correct.
And now it's down to a few.
Correct.
So they have liabilities that they have to take care of.
Right.
many of which may have come from AIK's failure.
Substantially, yes. We're mostly talking, to be honest, we're talking a lot about AIK, the fallout still from AIK.
And, pushing us back in assessments on these small groups is probably going to be enormous. And I don't have the solution right now, but is there a way that we could come up with something to get us through this period until a budget session next year? Is that kind of what you guys might be here recommending, or I don't know if recommend is the right word?
Well,
but
the difficulty is, and I understand that it's a good question. The difficulty is, and this is where it's frustrating, is that we don't have the authority to, within the DWC, say, do this, we'll fix the problem. We can offer some options as concerned as you are as well, and those options, and I'd be glad to speak those options being either to the assessments or to borrow the money, within the group to borrow the money, or to seek an appropriation from the General Assembly, or some combination thereof. And the question, of course, being, this is a whether to open the budget and so forth. The issue can be is whether and the fund can speak, the self-insurance group fund, they can speak for themselves. But the question being what you just asked, sir, do we look for sufficient money to get that fund, I say to get that fund to July, essentially July of 2024, to make sure there is not a shortfall come June, come July, come August, in which which injured workers cannot get covered. To get that gap between this and then an opportunity for this legislature to come say, let's figure this out more so. We can talk about a gap for that period, or to try to take care of it all right now. Again, the self-insurance fund can better speak for themselves on what options they believe. But the options that we see, or we can only recommend, again, for the legislature to decide, is assessing, and they have assessed. They assessed just recently. They did assess first. They assessed in, I believe, the end of this year, and they're assessing again this year, which will get them to that summer date. We'll get them to that. And then the issue becomes, well, do they seek to borrow money to cover that? They have the ability to borrow money, and Commissioner Clark can speak to that. Or they seek an appropriation and so forth when this legislature, and again, I come back to some hybrid, some combination of the above. But again, it's Representative Gentry, it's a deep concern I have too, because we have never, ever in a situation in Kentucky failed to pay for an injured worker. What is the solemn promise? You get injured on the job, you have workers' comp. And I'm concerned that this is coming up and that may occur.
yeah, we definitely want to avoid that at all costs. So I thank you for that answer. I guess if I was going to ask one more question, Mr. Chair, again, I'm trying to wrap my mind around this. If we try to put this impetus back on the remaining members of this group, can they even sustain this? I mean, what kind of monies are we talking about, and what would we be asking them to pay in an assessment if we had to go down that route without any kind of
So Representative Gentry, as you aptly noted earlier, there were about 17 groups that were part of this about 2 decades ago. Now we're down to between 2 and 4, depending on who you talk to. Simply put, assessment is not going to be enough to get to the number that we think will get us to June 30th of 2024. So we're looking at a potential solution of assessment plus, and then that plus is really falls to you as the legislature, and that's, do we require that these groups loan themselves money, and then the second option is an appropriation, is sort of a stopgap solution to get to that point. And I believe the self-insured groups can speak more clearly about what they believe that number to be. I believe they testified last week that it's something like $1.3 million. And they're here today as well.
Okay, thank you for that. I just hope in a day where we have rainy day funds there, of course, trying to get funds in a non-budget year this year is kind of like taking a steak away from the dog that hadn't been fed in a week. So,
I'll love the way you put that, sir.
but yeah, I certainly would hope that my colleagues would take this very seriously and figure out whatever options might be on the table and act appropriately, which is quickly. So, thank you.
Thank you.
Thank you, Representative Gentry. Can you explain, this is new to me, it's a new world to me.
Sure.
So can you explain the difference between Kentucky individual self-insured fund and the Kentucky group self-insured fund?
Sure. I'll give my best way to explain those different funds. It's easy. One is easy, the coal group. That's just what it speaks to. There's three funds we are speaking of. Again, we're talking about the Kentucky Individual Self-Insurance Guarantee Fund, the Kentucky Gold Employer Self-Insurance Fund, and the group fund. And what we're talking about here today is the group fund. Those are basically made up of different self-insureds who have come together. What the group fund is different self-insured group that have come together to join as a group. For instance, it includes AGC. At one point, it included KESA, include AIK, which AIK was a self-insured insurance company. Associated Industries of Kentucky's Self-Insured Group was the full name for that. So that's what we're talking about here. It's different than the individual insurance and different than the coal producers. These are actually groups of self-insureds that was permitted under this legislation that was created, I believe, in 1996 for the self-insured guarantee funds. So what the primary issue was, the first two funds, the individual the individual fund, self-insurance fund, and the coal employer self-fund, those are different. They're security. We maintain and watch that security. It is that third fund, the group fund, it was treated differently, and by law, by the statute. And again, it's those group of funds. That's what brings that together. Does that help explain a little bit? It's groups.
Yeah, yes, sir.
Yeah.
Yes, Commissioner.
It is complicated. And if I can go back maybe a little bit more,
Yes, ma'am.
you can buy workers' comp from a private company, from a Zurich, or, there's multiple what we call commercial companies out there. But when you get into the self-insured, it's when they elect, to go and take on their own risk. And how complicated it gets, Chairman, let's say, Sharon Clark works for ABC Widget Company, and then ABC Widget Company joins, affiliated with Associated Industries of Kentucky. And there were 4,000 of those, kind of like employer. Mm-hmm. And then AIK Company enters into the guarantee fund, along with all of these others that Mr. Flynn has mentioned. So it was a multi-level. But again, the intent, rather than buy it outright from, one of the commercial carriers, they elected to do that. And it's similar to health insurance. We are self-insured with the state employee health group. They don't buy it from the commercial market. We elect to go together. So that's the difference and I hate to get so basic, but I know it's a complicated issue.
Like basic.
Okay, but when you think about it, when we use that term self-insured, that's the difference, as opposed to buying it outright from a individual private carrier.
When you're talking about the fund that's going to have a shortfall, and you say there's no law that would allow you to go to another fund to bring it in to cover that shortfall.
That's correct, sir.
Is there a fund that you could borrow from if there was a law that allowed it? Is there a fund that would cover that until you could get an appropriation like next session?
No, sir.
Okay. So when you say shortfall, there's no way to cover it, even if there was a law saying you could cover it from another pot.
We do not have that, sir, no.
Okay. All right. Any other questions? Commissioner Clark, Commissioner WILHOITE, and sir, thank you for coming today and for your presentation.
Thank you.
And is there any other business that we need to do? There's not, is there? Okay. All right. The next meeting will be March the 1st at 12 o'clock here in room 171. If there's no other business, we move to be adjourned. Thank you.